Well, good evening, everybody. Well, good evening, at least in Ottawa, where it is 8:30. It is already tomorrow morning in Sydney, Australia, from where we're joined this evening by Dr. Janina Bowie. Janina is a senior lecturer in the University of New South Wales Faculty of Law and a member of the Gilbert and Tobin Centre of Public Law. She's going to be talking to us this evening about her co-edited collection, co-edited with Katie Miller, called The Automated State. But let me tell you a little bit more about Dr. Bowie before I turn the floor over to her. Her work focuses on the interaction between human rights and judicial review of administrative action, comparative administrative law, statutory interpretation, and the nature and limits of the constitutional powers of the judiciary and legislature to hold the executive to account. Dr. Bowie holds a PhD from Monash University, for which she received the 2014 Molly Holman Doctoral Medal, undergraduate degrees in law and economics from Sydney University, and an LLM in government law from the Australian National University. Dr. Bowie has written and edited many studies analysing the relationship between government and citizens. Her monograph, Human Rights and Judicial Review in Australia and Canada, The Newest Despotism, Hart 2017, examines the effect of judicially enforceable human rights charters on the development of the principles of judicial review of administrative action. She co-authored Government Liability, Principles and Remedies with Ellen Rock and Greg Weeks, and Public Law and Statutory Interpretation, Principles and Practice. Dr. Bowie has also co-edited collections on the legal protection of human rights in Australia, published with Hart, and Interpreting Executive Power, published with the Federation Press, and the Automated State text, also published by the Federation Press, is subtitled Implications, Challenges, and Opportunities for Public Law. And so, Nina, it's a pleasure to welcome you to the Administrative Law and Governance Colloquium, and I and our attendees are very much looking forward to hearing about this fascinating book and the future of administrative law.
Thanks so much, Paul. I really appreciate you inviting me to speak at this in this series. It's a very exciting opportunity. So as Paul said, I, along with Katie Miller, recently edited a collection on the automated state. It's focused on Australian law, but because of my background, I do bring a comparative lens to a lot of the work that I do. But because it's so focused on the Australian experience, I thought I might start by giving you a background of some of the things that prompted our decision to do this collection, and why we were sort of inspired into action. So hopefully this isn't too boring for those of you who just want to hear about automation, but I think it's important to paint that background picture. So basically, the Australian federal system of administrative justice, many would have described in the 1970s and 80s as, leading edge in the common law world. We have at the federal level, and then later developed at state and territory levels, a system of administrative justice which is sort of attempts to be fairly comprehensive. We have a judicial review statute which codifies, in a common law sense, the principles, the grounds of review, as well as the process for applying for review and the remedies, and makes application simpler. We also, in the 1970s, got a generalist merits tribunal, and that was pretty groundbreaking at the time because it came alongside a policy that, or a presumption really, that administrative decisions would be subject to tribunal review by this expert merits review body, which performs a different function, obviously, from judicial review, as we have a strict separation of powers at the federal level in Australia. We also got a Commonwealth Ombudsman, and then a few years later, freedom of information laws. But most importantly for the story that I'm going to tell, we got an administrative review council alongside those reforms, and that body was an expert advisory body which had a role in advising government of emerging issues within the system of administrative justice, and providing advice on how those might be dealt with, both small and large scale. And that body was made up of eminent public servants and academics, and really played a pivotal role in advising about a range of emerging issues over its lifetime, including in 2004, it wrote a leading report called Automated Assistance in Administrative Decision Making. And I've put a link to that on the slide. I'm happy to share that, but it should be relatively easy to find. And that was an early comprehensive report looking at the challenges that automation in government decision making has for administrative law, for the system of administrative law and justice. And it was a very early and comprehensive look at that issue. And it came alongside, or a few years later, the Commonwealth Ombudsman, who was a member of the Administrative Review Council, drafted a better practice guide, which set out principles for governments deciding to automate what they need to take into account. And I don't think the basic principles set out in the ARC's report or the Ombudsman's Better Practice Guide would come as a surprise. They, now at this point seem pretty self-evident. They were things like that there should not be any loss of rights to review or to access information when decision-making is automated or assisted by automation, that discretion is not suited for automation, that there should be some mechanism to ensure that systems accurately reflect law and policy, that there should be legislative sanction required for government decisions to automate aspects of their processes, that systems should comply with basic administrative law principles, and that they need to be explainable, and humans should retain responsibility for the systems at law. So those are some pretty basic principles, as I said, set out almost 20 years ago now. And I would suggest that at the time they were fairly leading edge. And Australia might be described as sort of a leader in thinking on some of these issues, at least the government through those reports. But the story doesn't end there. The experience in Australia has been quite different, despite really quite clear guidance from those expert administrative bodies. And I should just pause to mention that the ARC no longer exists. It was stripped, well, it exists, but as a shell, as a statutory shell, it was stripped of its funding, and so now is not able to continue its work. So despite these expert guidance on the issue of automation quite early in the piece, what's become clear, particularly over the last few years, is that that advice is not being followed. And I'm assuming that some of those here, or many of those here, won't be familiar with what's been going on in Australia. So I'm sorry for those of you who are. I thought I'd just briefly give you an introduction to the debacle that we colloquially call robo-debt, for those of you unfamiliar. So robo-debt was formerly known as online compliance intervention. And it was essentially a method of calculating possible social security overpayments, which automatically then issued show proof notices to people who had been on social security payments and had the system picked up as having potentially been overpaid. And it began in 2016, in the middle of the year. And there are several problems with this system. Problems is probably putting it lightly, but probably the main one was the way, the method of automatic calculation. So the system calculated debts using income reported to the tax office, measured against income reported to the Social Security Agency or Centrelink. And the problem with using those two different reporting amounts was that they calculated income over different time periods. So tax reporting is over a year. Taxable income is assessed over a year, whereas eligibility for Social Security is assessed over a fortnightly period. And so it's pretty easy to imagine a situation where somebody is on Social Security benefits for 6 months and then gets a relatively high paid job after 6 months. They were still eligible for the 6 months that they were on Social Security, but if you averaged their income over the tax year, then it would look like they were never eligible. And so this matching of data that was collected for different purposes over different time periods obviously led to an incredibly high error rate in calculating potential debts. And this wasn't actually new. Tax data had been matched against income reported to Centrelink prior to robo-debt. What was new was that prior to 2016, a person in government, in Centrelink, would look at this potential error and then go back and see whether it could be explained by the person's welfare records. And usually it could, and then they would know nothing further about the fact that they might have been investigated. But what happened in July 2016 with the OCI was that it was assumed that a discrepancy between tax and Centrelink data was an assumed debt, and a letter was automatically sent to people asking them to show proof and adduce evidence that they did not have a debt. And often these debts were from many years ago, up to 10 years ago. And so you can imagine that having to go back to employers and find and locate pay slips from 5 or 10 years ago is a really onerous and sometimes impossible task. And there was a huge number of people who were being called to do this. Another problem was the misleading communication with past welfare recipients. So the first tranche of notices suggested that there was a presumed debt, that it was a debt owing, when in fact they were more like show cause notices. Because a lot of the debts were quite old, or the alleged debts were quite old, Centrelink didn't have updated information from the people that they were claiming owed them money. So, for instance, if you had been on Social Security in 2005 and had gone off Social Security benefits in 2007, there was no need to continue telling Centrelink what your address was, and they might have an old address. And the result was that people didn't notice and the opportunity to explain why they did not have a debt. A 10% debt collection fee was added if someone did not explain or provide evidence of not having a debt. And finally, most of the debts weren't able to be explained. So even when people did ask for further details about how the debt had been calculated, often the people within Centrelink weren't actually able to explain how the debt had been calculated. So I'd say that raises some pretty big red flags for any administrative lawyer. And it will be unsurprising that there was a fair bit of criticism of it, and emerging criticism as the program continued. So what did administrative law do? Well, the Ombudsman investigated, as is their role, to look at systemic issues in administration. But there were some issues with the Ombudsman's report. It was a fairly weak report. First of all, it assumed that the program was lawful, despite questions being raised about that. And its recommendations really were quite narrowly focused on improving the administration and communication of the scheme, not on its fundamental flaws and the fundamental problem of such a scheme like this from an administrative law, a fairness, a social justice perspective. Senate committees also looked into the scheme and as well as in Senate estimates. So, obviously the Senate tried to hold government to account and raised the more serious systemic issues, including the lack of procedural fairness, the effect on vulnerable groups, the cause of stress and trauma, and also raised the potential illegality. And the Senate committees tried to push government on the legal advice that it had about the scheme. But the government's response was largely blocking, and then, at least in the early years, to defend the scheme as doing exactly what it was intended to do, which is reduce the costs of recovering debt and place those onto people who were presumed to have a debt. And the Senate committee reports and estimates reports from 2017 and 18 in particular are quite shocking in the government's responses, talking about how effective this scheme was in recovering debts, and it was doing exactly as planned. Several people also went to tribunals because, of course, we have a generalist tribunal, and there is a right to seek merits review, which is a de novo review of these decisions. But explainability was a problem. The tribunal frequently struggled to understand how the debts had been calculated. But an even bigger problem was the government's failure to comply with basic model litigant rules. And I think it probably even goes further than saying non-compliance with model litigant rules. There were, definitely not acting in good faith in the way the government dealt with the tribunal system. So, for example, it was common practice to wipe debts before they got to an AAT2 appeal, which is an appeal from the first instance appeal, so sort of the second tier of merits review. And the reason why debts were often waived before, when it looked like an applicant might appeal to the AAT2, before they got there, is because AAT2 appeals are public and are reported. And so essentially, whenever anything looked like it might get questioned, the lawfulness of a debt, the correctness of a debt, or might get to the courts, it was settled or wiped by government. So there was no longer a matter that would proceed. And of course, no one would seek to pursue something where they no longer had a debt. So there was a lot of secrecy surrounding it and a failure to front up to questions about whether or not the scheme was lawful. And as a result, the courts were very late to be able to consider those questions of lawfulness, and were essentially not able to perform that function until 3 years after the scheme had started and a lot of stress had resulted. They finally did in a case called Amato and the Commonwealth, which was brought by a Victorian and supported by Victorian Legal Aid. And it involved a purported debt from the 2011-12 financial year of just under $3,000. And in the end, the debt was calculated to be around $1.50, and Centrelink generously waived that. But that just shows the problem, that the factual issues with the scheme that resulted from mismatched data. So Ms. Amato had received a letter in 2017 to her old address, because she'd since moved. And the first she found out about the debt was that her tax return was garnished. And her lawyers argued in proceedings that the scheme was unlawful, that the averaging was unlawful, that the reversal of the onus of proof was unlawful, that the application of a 10% penalty automatically was unlawful, that garnishing someone's wages without any notice or someone's tax return without notice was unlawful. And 2 weeks after she filed in the courts, the Commonwealth conceded that the scheme was unlawful and agreed to pay back 470,000 debts, totaling 721 million or thereabouts. And the judge in the case said that the information before the decision maker, that is the average data, was simply not capable of satisfying a decision maker that a debt was owed. So quite quickly after Amato, a class action was also brought to the courts, arguing that the averaging was unlawful and had resulted in unjust enrichment by the Commonwealth. The Commonwealth knew that the scheme was unlawful, that the economic loss that was caused to some previous welfare recipients had arisen from the Commonwealth's negligence, and seeking damages for the stress, anxiety and stigma caused. That was also settled around the same time in late 2019 without going to hearing. And the Commonwealth agreed to pay 122 million in damages, plus refunding the debts and not pursuing other debts that it had given notice of under the scheme that had not been paid. And so the total cost to the Commonwealth was 1.8 billion. And on the side of this slide, I have just highlighted the ministers that were involved in implementing this scheme. So the reason why I've gone through robo-debt is because I think that it has brought out some issues that are really relevant to the Australian experience. And also because I fundamentally disagree with some of the conclusions that were drawn from it. And primarily, I disagree with its characterization as a failure of automated decision-making. So there was a lot of media and some academic commentary which referred to robo-debt as a problem of automation. And we should all fear automated decision-making because look what happened with robo-debt. I don't think that's a correct characterization of what happened. Rather, I think it's a moral failure. I think the challenge with automation is that it makes the impact of bad government policies and practices faster and more widespread, and in this case, devastating. What the robo-debt experience also demonstrates is that administrative law institutions are vulnerable, that they have gaps in their capacity to respond to some of the significant challenges of automation. And another Australian example demonstrating that is the case of Pintarit and Deputy Commissioner of Taxation, which I won't go through, just very briefly. The key lesson from that, or the finding from that, the decision of the full federal court, was that an automatically generated letter was not a decision for the purposes of administrative law, meaning that it could not be challenged and the government could not be held to it. So that in this case, a taxpayer who had evaded his tax obligations had a conversation with someone from the Department of Tax or the tax office, and following that conversation received a letter saying, if you pay by this date, this is how much you owe. He borrowed money in reliance on that letter and paid the full amount of the debt, but that debt had been erroneously calculated and automatically generated, and the tax office then went on to increase it, so he hadn't fully paid off his debt. He also still owed a general interest charge. And the question for the court was that automatically generated letter a decision? And the majority of the court, with Justice Kerr dissenting, held that it was not, that a decision required a mental element. And so that's quite concerning, I think, because it shows that there are vulnerabilities in the courts as to their capacity to review automated decisions, or decisions that are with a large amount of automated assistance involved in them. So that and the robo-debt saga and shows just how vulnerable administrative law institutions are, or the gaps rather in administrative law institutions. The other thing that I think is really notable about robo-debt is that the ARC and Ombudsman's recommendations from 20 years ago rely heavily on government complying with best practice, and they set out best practice principles, but government will not always comply with best practice principles, and that's why it's concerning that institutions have gaps and vulnerabilities. Indeed, the year after robo-debt was settled, the government announced plans to automate another social security scheme, the National Disability Insurance Scheme, and decision-making under that scheme, suggesting that, and along very similar lines to what had been done in robo-debt. And I think that demonstrates that these concerns, remain alive. The other thing I think robo-debt tells us is, given all of these things, given that there are gaps within our administrative justice system and we cannot rely on the executive to act in accordance with best practice in all instances, Parliament needs to legislate. It needs to take control because it's the only institution that has the power to do so, and it's appropriate for Parliament to do so. But what robo-debt also does is highlight some new problems and highlight the challenges of automation and the importance of government accountability. And that, I think, is a good thing, that it brings to mind some of the challenges that have been a concern of administrative lawyers, but not as much of everyone else. And so even though it was a devastating program, I think it's ultimately a good thing that it shed light on this question of when is it appropriate for governments to automate and what controls are required. So that's, I guess, a background to what prompted this book. And I'll confess at this point that, and you probably have already picked up from the language that I've used, I am an administrative lawyer and not in any way a tech person. I did a short online course in programming at the start of last year, but in no way does that make me an expert. I am mildly, I understand what Python is, but that's about it. And so please forgive me when I consistently use the wrong words and phrases. Hopefully what I'm getting across is comprehensible, but the very fact that I'm an administrative lawyer, I care about this issue but have gaps in my knowledge, highlights the reason behind this collection. And that is, often we're talking at odds with one another. We find that administrative lawyers are saying one thing, computer scientists have different understandings of the same words, judges see different problems from tribunal members, people working within government are confronting a different situation. And so what Katie and I really wanted to do with this book is two things. One, to bring all those people together in a workshop and get them to talk to each other, which we did successfully by bringing together, legislative drafters, computer scientists, judges, government lawyers, policy people, and academics, bring them all together to share their ideas and look at each other's proposals. And the other thing we wanted to do was get deeper explorations of the emerging issues in automation, because the ARC and Ombudsman's best practice guides are great, but they don't address some of the new and emerging challenges that are evolving in automated decision making. They're very much based on a notion that, that a decision involves the system applying the law to a set of facts, but there are a range of other functions and relationships that are performed by automated systems now. And I didn't think that the Australian literature had fully grappled with some of them in detail. And so that's what this collection tries to do. It brings people from different backgrounds together and tries to delve deeper into some of the modern issues and bring those perspectives to them. So the chapters include, and the issues that we look at include, the role of the private sector in building and operating automated systems, the challenges and opportunities in rules as code, the role of automated systems in legislative drafting, procurement, the role of tribunals, and a computer scientist versus administrative law view of explainability. So what I'm going to do is focus on two of those things, if I have the time. And they're the two chapters that I was involved in. So the one on rules as code, which I co-wrote with Lyria Bennett-Moses and Dr. Lisa Burton-Crawford, my colleagues at UNSW, and the role of the private sector in building and operating automated systems. So I'll give you just a quick overview of our arguments in each and what I think are the interesting and lesser explored challenges in those areas. So the rationale for rules as code is that legislation, as we know, is voluminous and increasingly complex and changes quite frequently. And Calabrese has done work on that, and more recently in the Australian context, my colleague Lisa Burton-Crawford has done some empirical research highlighting the nature of legislative complexity and volume and flux. And that leads to various challenges for government and for those dealing with legislation and those affected whose rights and obligations are set out in legislation. So it makes it more difficult for administrators to administer the law and to understand and know what the law is. It makes it difficult for those who are subject to the law to understand their rights and obligations, makes it difficult for everyone to navigate the law. And it also takes an enormous amount of time to make decisions because of the volume and complexity of it. And so I've cited, I think the work of Ed Rubin is particularly influential in detailing some of those challenges, but also in the Australian context, John McMillan and Lisa Crawford have done some work there. And I think machine readable and consumable legislation can really help address some of these challenges. And we shouldn't be entirely pessimistic or opposed to automated assistance in administrative decision-making, because it does help solve some of the challenges of the way legislation is used and administered now. Making laws machine readable and consumable can help with transparency. It can help making the law more accessible. For example, apps can be built which assist industries with regulatory compliance issues, so that they don't need to seek legal advice on every occasion. It's much simpler, for instance, to understand planning rules. And of course, machine consumable legislation can assist with automating decision-making and making it more efficient. But it also, the process of making laws machine readable and consumable also involves some challenges and can create some problems, including errors in translation, because of course the law remains the law and there is a translation into code, and we need to be able to ensure somehow that the translation is an accurate reflection of what the law says. And as I highlighted with robo-debt, the errors become a much bigger problem when they are there, the errors in translation. So one response to these challenges is the rules as code movement. And essentially that movement attempts to do two things, or is looking at doing two things. The first one is looking at the process of making machine consumable legislation, and the other is publication and transparency of machine consumable legislation. So in terms of the process of making machine consumable legislation, one of the things that is that's looked at and used is co-drafting to reduce error. And those of you in bilingual jurisdictions will be very familiar with the processes of co-drafting. But of course, the process of co-drafting and working with a coder to write legislation that can be translated into, or that can be write legislation that can easily be translated into code and work as machine consumable rules, is that it might and has affected the content of the law. So it drives the way the law is written. And an example of that comes from the UK and the Johnson case, which involved looking at the UK's universal credit system, which was actually designed using general rules for the purpose of facilitating automated delivery of the credit system. And the result of using general rules was that it was quick and efficient to administer, but it resulted in unfairness for certain categories of people, particularly those who had regular salaries, the payment of which was affected by public holidays or, weird dates in months, and they might get 3 fortnightly payments in one month and only one in another. And the result of that was that their monthly income fluctuated, but in actual fact, it didn't. And the court held that this was known to the government when it made a conscious decision to design the legislation, design the rules so that they could be automated, and that the failure to enact an exception was irrational in the regulations. So, and there are examples. So basically the rules as code movement looks at the process of making machine consumable legislation and that co-drafting, and also ways of publishing the legislation to make it more transparent. And there are examples of it from across the common law world and the world generally. New Zealand was a leader, but there are also examples from Australia and Canada and other countries. But we highlight some of the rule of law challenges of the rules as code movement in my chapter with Professor Bennett Moses and Associate Professor Crawford, which include how and who creates it and responsibility questions. And I'll talk in a moment about the role of the private sector in creating laws. So I'll leave that for now. But of course, the accountability of those involved is a real question. We're used to parliamentary drafters drafting legislation. How do we know the process and the reasons why certain, why laws were written in one way rather than another in a co-drafting process, and relatedly the explainability of decisions to use certain rules in the code rather than others, or that interpretation. Another question is what method is to be used? That is it going to be the legislation being translated or a bilingual type method? And those challenges link back to the issue I raised just a moment ago about to what extent is the technology driving the content of law, but they also have some other consequences in terms of interpretation and status. So many of the benefits of rules as code that I've set out only accrue if the code has official status. But Australia has no doctrine of deference on questions of law, meaning that unless the code has the same status as legislation, the legislation will always have primacy, and any discrepancies in the code will not resolve the problem of translation errors. But on the other hand, if the two have equal status, then does Parliament need to enact the computer code? And does that mean that parliamentarians need to understand what it says? And I suspect that most parliamentarians do not have the capacity to read computer code, no aspersions, nor do I. But that raises questions of, well, to what extent do parliamentarians need to understand what they're legislating, and do they currently understand legislation? Is code more or less comprehensible compared with, legislation purportedly written in English? And is this a real challenge? Are parliamentarians more likely to, in time, be able to read code compared with legislation? And I think these are all questions that need to be addressed and that go to the root of what Parliament's role is, what it can do, what is legislation, and do our elected representatives need to be able to comprehend it? These questions also create, well, there are further questions that are related as to how inconsistencies between the legislation and code version are dealt with. And this obviously depends on the process of drafting that's used, as well as the status of each document. But it has effects or raises questions for interpretive canons, such as the shared meaning canon. And that raises questions in turn about whether judges therefore would need to also be able to read the code version. And finally, in Australia, we don't have any doctrine of legitimate expectation, meaning that if the code, or inevitably, despite the very best efforts, there will be instances of discrepancies between what's written in the legislation as interpreted by a judge and what is in the code. What happens to somebody who has relied to their detriment on the code, the official code version produced by the government, when we have no doctrine of legitimate expectation in Australia? Now, obviously, we think, well, perhaps not obviously, but in our chapter, we suggest that this particular challenge might be solved by a beneficial construction provision, but that also raises some constitutional questions. So that's rules as code, and essentially we pose these as questions, not necessarily answering them, but our point is to say that there are big and fundamental questions. Even though rules as code and machine consumable legislation can solve a lot of problems, these are significant questions that go to the very heart of our democratic and legal system that need to be thought through and addressed. The other thing I wanted to run through, the other issue that I explore in the book, is the role of the private sector. And again, I think this is another unexplored issue in automated decision-making literature. And it's the fact that usually government engages the private sector to build and maintain automated systems, and sometimes to operate them and own the data. And even where it's just that minimum, the private sector building the system, I argue that that involves functions that are traditionally done by government. So the ARC and Ombudsman reports and guidance really, as I said, really assume a model of automation assisting or making decisions using a algorithm. But the reality is that automated systems, even where that where they're in the control of government and operated by government, decisions are made in the building of that system. And often they're made by the private sector because governments rely on the private sector to do this work. And that's because through years of outsourcing, governments don't have the skills or expertise to do this work, and arguably nor should they. But it raises real rule of law problems and administrative law problems specifically, because in the process of translating legislation into code or interpreting legislation, interpretations are done, right? Whoever's advising of the code, working on the code version, has to make interpretive decisions about what the legislation means. And as I've mentioned, in Australia, we don't have a doctrine of deference, but I think that this is a broader problem even where there is such a doctrine, because it's necessary to be able to understand what that decision was, what interpretation was used and why. And that's not always possible, as I'll explain. So there are also decisions being made about the policy and procedure of administration when automated systems are being built to administer the law. There are decisions being made about how law should be administered, what processes and policies should be applied. And I've already mentioned the third way that the private sector makes decisions and influences government administration and potentially law is that technology can drive the content of law and the design of a regulatory scheme. So I think we need to acknowledge that where the private sector is building an automated system or working with government to do that, the private sector is doing some of the work that's traditionally done by government, and appropriate accountability is required. And the Australian government, at least, is not alive to these issues. And I think that's demonstrated by their response to a recent Senate inquiry looking at a proposed automated visa processing tool, where the Senate raised some of these issues and said, you know, how will we ensure that the system accurately reflects the law? And the government's response was, well, the outsourced provider isn't making decisions. They're not involved in administration. This is merely a workflow tool. So I think that there are real concerns about whether the government is alive to the fact that the private sector is doing the work of government when it's involved in designing and potentially operating automated systems. So in my chapter on this issue, I go through some of the problems that this presents, as well as some of the solutions. So a big problem is a more general problem in automation of administrative decision making, and that's access to information. In my chapter, I describe that problem as locking a black box inside a safe, because the automated systems are often described as a black box, and that's the case, you know, more so with certain kinds of systems, machine learning systems, but it's also the case where there's an insistence on trade secrets, government secrecy as to the content of that system. And it's also the case if the same people who are using and interpreting and making the law don't understand what's in the code. And the safe is, of course, the outsourced aspect, and that is the fact that outsourced functions are often protected from usual oversight mechanisms. Commercial in confidence is often claimed. And so there's sort of a double barrier to accessing information. There's also access to information challenges due to a lack of explainability or expertise within the public sector, which can make it challenging for courts and tribunals to do their jobs of understanding what's the correct decision in the case of tribunals, and in the case of courts, determining whether a decision has been reached according to law and reason. And then I've mentioned the other access to information problem, which is claims of commercial in confidence under various information seeking regimes, including freedom of information and Senate requests for information. It's quite common for governments to claim that outsourced functions are protected. Outsourcing and automation, the outsourcing of automation also obviously raises privacy and data security challenges, particularly when the provider maintains the data and retains control over the data. And this can be the case even where the system is built by government, as was the case with the Australian Electoral Commission, for instance. In one example of it using machines for voting machines, and the private provider maintaining the data for an extended period, and difficulties in getting that data wiped and out of the control of the provider. And Australian law is particularly weak in privacy and data security. So those are the challenges that I raise about the nexus between outsourcing and automation and the fact that the private sector is so often involved. I also do provide some solutions, but I think ultimately the clearest and easiest would be for governments to adopt best practice. But here I refer back to my discussion of robo-debt. That's simply not always going to happen. I think that the examples that I've used of the proposed visa processing system and the proposed automation of the National Disability Insurance Scheme, both of which have now been scrapped, but those post-robo-debt examples show that governments don't always adopt best practice. And I think what's particularly concerning is that all of those examples, and many from around the world, involve vulnerable groups of people. Asylum seekers, people on social security, people on disability allowances and benefits. And I think that's a pretty common theme, and a really concerning one is that best practice is often not adopted when it comes to vulnerable groups of society. So that would be the easiest solution, but I don't think we can expect it in all situations. I argue in the chapter that courts and tribunals could do more than they are doing in Australia. For example, I don't think that the Pintarich decision was inevitable, and nor do I think that tribunals, when confronted with information that they don't understand, have no option other than to say, well, the system reached this outcome, even though I don't understand it, this is the outcome. I think that tribunals, their role is to reach the correct and preferable decision, and if they're not convinced that the debt produced by a system is the correct or preferable one, then they can easily say, well, I'm not convinced that this is the correct and preferable decision in this instance. Similarly with courts, I think it would be within their power to say, we cannot be convinced that this decision is reasonable if we cannot understand it, and therefore it is unlawful. If it cannot be justified, or if we can't understand the justification given. So I think that there's scope for courts and tribunals to provide more oversight than the case law and experience in Australia suggests that they might, although I'd also stress that none of these issues have been considered, and that, or not finally determined, and that there haven't been a lot of cases on this question in the Australian context. But ultimately, I think there's a lot of this area where Parliament is the only and best option and must take responsibility for the area. Australia's data protection and privacy laws need to be strengthened to respond to these challenges. But Parliament also needs to ensure that we have strong, independent administrative law institutions with proper and full capacity to review the lawfulness and properness of these decisions. So those are the two issues I really wanted to highlight, and the Australian experience. I'll leave it there, but I'm happy to talk to answer any questions.
Well, thank you, Nina, for that tour de force. Last week we had Professor Sharkey from New York University, who had, I'd say, maybe a more optimistic view of the future of technology in administrative law. But I wanted to ask you right off the bat a long question to allow you to catch your breath a little bit. And I'm kind of wondering, as I listen to your presentation, whether technology, and you mentioned this at the outset, that the problem with one of the things that RoboDebt highlighted was that when there's maladministration and it's automated, things get very bad very quickly. And I wonder if some of the phenomena that you were highlighting aren't examples of existing pathologies of administrative law, which are simply highlighted and possibly aggravated if they're not responded to when we have automation. So for example, the level of ambiguity or uncertainty in statutes, regulations, and policies, the fact that rules sometimes operate harshly at the margin, the fact that outsourcing can shelter exercises of public power from proper scrutiny, the fact that sometimes it's difficult to get information about how decisions were made in an administrative structure. These are, you might say, pathologies of administrative law, and the move to automation simply highlights or maybe aggravates these pathologies. What do you say to that?
Absolutely. I mean, I think that's the fundamental problem that I have with a lot of the reporting and analysis of RoboDebt, is that I don't think it's in any way a failure of automation. I think automation can help with a lot of the really big challenges in government administration and can improve efficiency and access. I don't think it in itself is the problem. I think you're exactly right that the problem is that it exacerbates and makes unlawfulness and maladministration wide scale. I mean, you know, I worked in the social security area as a lawyer for several years, and I routinely saw bad administrative decision making, but not 470,000 examples of it in a 3-year period. And likewise, outsourcing, the problems with commercial in confidence are long-standing, but when these are decisions affecting 500,000 or more people, that makes it a much, much bigger problem and not necessarily more urgent, but I think it just systematizes existing problems with administration. And that's why it needs much more careful oversight because of its propensity to affect that many people, and particularly vulnerable groups, which seems to sadly be the area where this is done worst.
And we go to the phones or the automated equivalent of the phones, which is the Q&A box. If you have any questions for Nina, do pop them in. One questioner is asking to follow up on the point you made about Parliament perhaps legislating safeguards in this area. What sort of, that follows on from the discussion we've been having, what sort of safeguards could a legislature at the federal level or at a state level, what could they put in place to give us some comfort that the pathologies of administrative law won't wreak havoc on hundreds of thousands of unsuspecting citizens?
Well, that's a really good question, and I think you know, it's not something that I've fully thought through, but I have definitely pondered many times whether it would be a good idea to, for instance, give the Ombudsman a lot more money and specialist people and a role in checking that any system that's being used is explainable and complies with the legislation. So any automated system that is being delivered is checked by an independent, well-funded expert section of the Ombudsman. or some other independent, properly funded body to ensure, to provide a sort of external check on the decisions that are being made about the system that's built. I think that's one thing that Parliament could legislate for and fund. Other things would be to amend the Freedom of Information Act to seriously narrow the commercial in confidence provisions, and potentially say that they don't apply where a system is being used to determine government entitlements, for instance. Now, whether government would actually comply with FOI requests or, orders to access information is another question, but I think that those laws could definitely be strengthened. Yeah, those are a couple of examples, but I guess I think raising these questions itself is new, and these are things that need to be nutted out by not just administrative lawyers, but people who actually understand programming beyond a 6-week online Python course that I nearly didn't finish, and and people working in the area, people with understanding of procurement processes. So that's another challenge, I think, is that the solutions need to be acceptable to all of those groups of people who are using and affected by and interpreting and making the systems and the laws.
That response has prompted a question, and I'm going to read it's a question with a bit of a wind up and then a pitch, but the pitch relates to what you were just saying. So the questioner is a policy analyst in AI governance, and finds that a common refrain is that because there's little to no case law surrounding AI in the jurisdiction, we can't know how legal challenges will pan out. And goes on to say that as a result, our institution lacks a common approach, and those proposing AI use cases are often more willing to assume risks because we don't have guidance based on case law. So do you have any advice as to what those working in government can do to advance our institutional understanding of administrative justice / procedural fairness in this new space?
Yeah, I mean, I'm not sure that courts are a particularly good avenue to rely on, really, to answer a lot of the questions, because of course they come with real challenges and access barriers. I mean, I think it's fair to assume risks, but only where those risks are for the benefit of people. And I think, some of the examples that I've used show that it's not just majoritarian benefits that we need to be looking at. We need to be looking at exceptions and fundamental principles like fairness in designing the systems and thinking about how they should work. So I think my suggestion would be to come from a best practice starting point of fairness for the most vulnerable and for the exceptions, as well as making things more efficient for the majority. And if the system doesn't do that, then it's not a risk that should be taken, because that's a fundamental thing that administrative law, that judicial review does, is those individual cases where unfairness has resulted or injustice has resulted. Those are the ones that the courts pick up on and use to define the law. And so if government can think of what those might be, and the UK experience shows that it was aware of them and just chose to ignore them, I think that would be a pretty good starting point, is not just what does this look like for the average person, but what does this look like for someone who struggles to access technology, for the most vulnerable users? What measures are we putting in place to make sure that this works for them as well?
Yeah, and I'd add to that answer that in subsequent seminars that we're going to discuss the General Data Protection Regulation in Europe as a response to this, and also the Directive on Automated Decision Making here in Canada. And the notion of vulnerability is, I'm not sure vulnerability as such is spelled out of a directive on automated decision making, but the greater the impact of a decision is likely to be, and that I think it's fair to say takes account of vulnerability, the more is required by in the way of process before the system is put into place. And that's an interesting approach, which we'll be discussing with my colleague, Teresa Scassa, in an edition of this colloquium next month. Another question, a questioner who says, I can't think of a statute without ambiguity or grey areas, often intentional but often resulting from the limited foresight of the legislators. What do we lose by forcing statutory language to have a degree of precision that can be codified in computer language? This seems like it would somewhat arbitrarily force legislators to introduce precision for which they are unequipped. Is that a problem? The questioner asks. You did mention when talking about the rule of beneficial construction, you construe ambiguities in favor of the vulnerable person. You did mention the possibility that there will be constitutional difficulties with that. Is that am I right to make a link there between this question about ambiguity and forcing legislators to be precise, or are we talking about two different phenomena?
I think the point I was making about construction is a sort of reliance point, where someone's relied on rules promulgated by the government. If they turn out to be wrong, the government should be held to the most beneficial version or interpretation.
Fair enough. Sorry, that's clear. Now, my poor questioner. Can my questioner get an answer to the question about whether we're losing something if we force legislators or other rule makers to be precise?
I think that's a really good question, and I'm not 100% sure. I think, I mean, it comes to, I'm not sure if this answers it, but I think that it depends on the status of the rules, right? Because no matter how precise legislators try to be, there's still decisions being made when turning that into computer code, right? To, ones and zeros. Like, there's no ambiguity in code. It's either yes or no. And so I'm not sure the English language can ever be that precise, first of all. Secondly, I think there is, because it results sometimes in stricter rules with less ability to be flexible according to circumstance. Maybe that's not so much an ambiguity problem as a discretion challenge, but I think there are definitely a lot of examples of attempts to be really precise and specific in legislation resulting in unfairness because certain people aren't taken into account or the exceptions aren't able to be considered. I'm not sure that answers the question. I think it's otherwise something I'd need to think more on as to, and probably it's a yes and no, as lawyers love to do. In some cases, it's probably really good for legislators to have to be more precise. In other situations, it's probably impossible or might result in unfairness, but I haven't thought it through enough to kind of come up with good examples.
Yep. Well, I just put in the. I think it is a very good question. That's a very good answer. I put in the chat a link to, or the title of the classic article by Julia Black from 1995 on rule types and discretion, which is a useful resource for anyone who's thinking through this. Another question, just a couple more, I think. I don't want to keep you from your lunch break. So you talked about the Pinterich case where an automated decision. This was a machine spitting out a tax letter, which led the taxpayer to believe he was getting a refund. And this wasn't considered a reviewable decision in the federal court because it lacked a mental element. Does that open a path to a challenge based on fettering discretion or other grounds of review? If discretion is expected but wasn't actually exercised, because in the end the decision is being produced by a machine, would that be a problem in Australian administrative law?
Yeah, look, I think, so first of all, in the Pinterich case, we shouldn't be overly sympathetic to the taxpayer because he did owe a very large tax debt to the Commonwealth, and that was not a question in dispute. The question was just how large is it and does he have to pay interest on it? And
to be fair, though, as common lawyers, Nina, there is a solid tradition of being in favour of taxpayers, no matter how deep their pockets are. We're always alive to the interests of wealthy taxpayers.
Yes. And it is an interesting case. And I should confess, I totally agree with the minority judgment in the case. And it was also in the quite specific situation of review under the Tax Act, which is limited to decisions. So it uses the term decision. So we're back to ambiguity. What even is a decision? And the very particular circumstances of that case, of that word in that act and in the ADJR Act, is the court said that it needs to involve a mental element. So I think that aspect of the ruling could definitely create other problems for judicial review under the ADJR Act, under our statutory judicial review scheme. But we also have other avenues of judicial review. We've got a constitutional one and another statutory one, which mimics the constitutional one. And then we've got, common law in the states. So I think different issues would arise in those jurisdictions, and the same mental element decision ruling would not apply there. Other issues would, however. For instance, the Commonwealth, the federal, the Constitution and the Commonwealth Act use the word officer of the Commonwealth. So one question which would arise is if a machine can be an officer of the Commonwealth. And again, I think it's something that could very easily be fixed by legislation or by a High Court ruling on who's an officer of the Commonwealth and can a machine be an officer of the Commonwealth, or can they be taken to be acting under the direction of an officer of the Commonwealth, for instance. But as the previous questioner identified, we haven't had very many cases on either of those questions. And so it's open, but definitely in the context of the ADJR Act, so that particular review statute and other provisions in Australian judicial review law that use the same term decision, this could have much wider reaching problems. Justice Kerr, who wrote the foreword to our book, which is very entertaining and involves a lot of sports analogies for those who enjoy sports and administrative law, he wrote a very, very compelling dissent in that judgment, which looked at broader issues of what are the ramifications of the majority's judgment, which I commend to anyone interested in the area. I think the whole judgment is fascinating, but his in particular.
His introduction is very good as well, though I would quibble with the description of Australian rules football as sport rather than just a moderately organised form of brawling. Last question. As automation gains steam, what are the best practices for embedding coders in the lawmaking process? Can this process be brought fully in-house, or will there always be some degree of private sector involvement because of the technologies being used?
Yeah, I don't know. I think that's probably something that those in government would have a lot of views on. One question I'd have is whether government can afford to pay coders what they're asking. They're a very in-demand bunch. And that skill set, having them in-house would definitely be of benefit, but is it realistic and affordable? I think if it becomes core work of government to make legislation machine consumable, then there must be some expertise within government working with drafters. But all the drafters I've spoken to have such exceptional specialist, finely grained skills that it's hard to imagine. It's hard to imagine how that could be properly understood by coders and, back and forth. I struggle, but, because they're both so highly specialized and experienced. But yeah, sorry, that doesn't answer the question at all. I guess I think there needs to be people with this expertise, with both expertise in law and drafting and in coding within government. Surely that will happen over time as more and more of us, become programmers. My friends with children, I gather all children are learning programming in kindergarten, if not earlier these days. And if even Luddites like me are, compelled to do a course in Python, then surely these will become skills that more and more people in the public sector have. But it's been decades of relying on the public sector, getting rid of technology skills from government. We currently and for the foreseeable future will have a real expertise problem in this area, and that necessitates relying on the private sector, which creates all the explainability challenges. But I think those are more solvable in the immediate term by scrapping barriers to accessing information. By a lot more transparency and explainability is maybe a bridging approach to dealing with those challenges before everyone learns to code and before we have governments who have the money to pay our very best coders to help with drafting legislation.
Well, thank you very much, Nina, for the fulsome answers to some very good and very difficult questions that were posed to you. I'd note as well that the Gilbert and Tobin Centre ran a recent series of blogs and an online webinar on the 50th anniversary of the Kerr report into Australian administrative law. You'll find some of the posts on my blog, Administrative Law Matters, and also on the Australian Public Law blog. And I'm guessing, I haven't gone and looked, but I think on the Gilbert and Tobin Centre's webpage, you'll probably find some links there as well. And that was a very interesting and engaging series, looking back to a time when Australian administrative law was, as you said at the outset, the best student in the class, and looking at some of the difficulties, pathologies more recently. And for anyone who's interested in thinking more about the issues that we've been discussing today through the lens of automation, that's a very useful series indeed, and another example of the great work that you and your colleagues at the University of New South Wales are doing. So it only remains for me to say thank you again to you, Nina, for joining us, and congratulations to you and Katie Miller on the Automated State, which is a fascinating collection which rewards reading even for those of us in the Northern Hemisphere. And we will be back next month with Sunny Kang from Eightfold AI to talk about the GDPR as a response to some of the problems that we've been discussing today. So thanks, Nina. All the best. And of course, it's summertime in Australia, so enjoy your walk on the beach this afternoon.
Thanks so much. I will.